Good evening, everyone. Again, thanks for taking a moment out of your Tuesday evening to join us to talk about legacy planning. It's appreciated. I hope that you find something valuable from this session tonight, or at least it will spur a conversation within your family, just talking about this concept. I know it's not as fun as maybe a nutrition wow event that we've done in the past, or a wine event, although you're certainly welcome to grab wine and enjoy this conversation with us. But I'm going to go ahead and get started and share my screen and just make sure everyone can see it appropriately, and we will begin. All right. Tiffany, can you see that fine?
Sure can. Looks great.
All right, awesome. Well, again, welcome to tonight's discussion. Tonight, we're going to be talking about legacy planning and estate planning, all the nuts and bolts that you may hear when you think of this concept. The way we're doing tonight's seminar is, again, if you have a question that comes to mind throughout it, please submit it. Lisa is going to be taking those questions and compiling them, and then in the end, we'll have a Q&A session. And Tiffany and I will be discussing different questions and answers during that. Again, I'm going to go through the slide deck that we presented and developed, so feel free, write anything down, and we'll be happy to discuss it. My name's Ben. For those of you, I think I've met most of you already, but for those of you that haven't met me, I've been with Halter Ferguson for over a year now, and I work alongside Tiffany in financial planning. Really enjoy the colleagues here and teammates that I get to work with every single day, and just serving you guys as clients and hopefully bringing ideas and solutions that make your lives better and hopefully give you some comfort as you progress throughout life. All right, disclaimers, as always. I know that you won't have time to read all this, but I do want to put this up here just so you guys can see it. Also, I'm not an attorney, nor do I intend to be. We have professionals that we pair up with and work along your side to make sure we're addressing your goals and that everything's being considered appropriately. So I think it's always important to start with the why. Why are we here tonight? Why do we choose the estate planning and legacy webinar for tonight's discussion? Most of all, estate planning is not the most beautiful concept to talk about. It can be painful at times, and just making sure that not only are your intentions taken care of during your life, but also that your intentions are addressed after life as well and carried out when you're not here to have say. Unfortunately, no one lives forever, and we don't get a pick necessarily when we get sick or when we pass away. So it's important to plan and facilitate those conversations. The other piece that it does is it allows you to focus on the emotions during those less opportune times where maybe out of emotion we would be making decisions and not be in the same coherent headspace because of all that's going on. The other piece too is protecting your nest egg and just making sure to streamline the probate process. Keep in mind as we go throughout tonight's discussion that everyone's estate planning situation is different. Everyone's goals differ to some level, and also state laws differ state to state as well. So hopefully this just helps you to begin or simplify or enhance that estate planning picture for you and your family. Just to paint a vision, a little bit about where we're going to go tonight. First of all, we'll talk about probate. I know everyone loves to hear that word. estate planning, shocker, we'll be talking about a lot of different components of estate planning tonight. Some goals that people have when it comes to estate planning, gifting, and some of the parameters around that, discussing beneficiaries and how they play a role in legacy planning. The big one that kind of spurred this talk tonight is the Tax Cut and Jobs Act being enacted in 2017 and how that's going to sunset at the end of 2025, kind of what that looks like. And then educational goals as well. All right. So before we begin and talking about all the content related to estate planning, I wanted to bring it back to our process at Halter Ferguson. It's definitely unique, and it's not like every single other planning firm. In fact, I worked at a prior firm before, and we didn't hit on these values or goals in the way that we do during the planning process. For those of you that have been, newer clients, you probably recall the values process that you went through. Also, those longstanding clients, you probably discussed these at some point throughout your time with the firm. And it may be a good time to also revisit your values and make sure that they're still consistent. But in specific here, I wanted to talk a little bit about some of the values that when they come up during discovery in that conversation, that it tips off a bell to Tiffany and I and saying, hey, estate planning might be a module that needs some attention here for this particular client scenario. So things we hear like security and stability, but keep in mind too that each term is subjective, right? So that's why we have this conversation around these terms, so we can understand, well, what does security mean to that individual and why was it chosen by them? Peace may be within family, or maybe they want peace of mind or confidence in their situation. Estate planning may come into play when I hear the word community, whether that's giving back to your local community. Others just want knowledge of, hey, how does estate planning play into my financial picture? And what does a gift look like? Do I have to file a gift tax return? Those things. And there's others that are loyalty, whether they've made a pledge to something in particular, monetary assets. Or maybe they promised something to a kid and they want to make sure that that comes through at the end of their life if they have the assets to do so. Then we talk about the goals piece. The number one, when we hear leaving a legacy, obviously estate planning is not only important at the onset of our relationship, but also as we continue to progress through the client relationship and tenure with the firm as laws change and such. Giving money to charity. Long-term care and medical costs. Definitely there's some estate planning things that can be addressed there to make sure that you're adequately getting the care and such that you deserve. College money for family, family gifting, and then unique collections. That being, maybe you have a heirloom collection of XYZ that's been passed down through your family that you want to make sure gets passed along in the appropriate way, and doing it through estate planning is the way to go. The other piece I'll say too, we've got this sometimes where people ask like, well, you guys do it differently. Why? And at Halter Ferguson, it's not just about managing your investments. It's not about just doing your financial plan, but it's also about having a relationship with you and having these values and goals in front of us. Not only allow us to help you make decisions and be a fiduciary, but also to know what's important to you and have that relationship that also makes that third pillar so much more unique. For those of you that are visual, I just wanted to bring this back to you just to show you a little bit of what this looks like, all the other values as well, not just the ones that relate to legacy. Hey, you can always make your own in the bottom right-hand corners of both of these so that we truly get to know what's important to you as we go throughout this process. And then here are the goals. So like if you're a couple, you would do the goals together. We have you come to a consensus on those. Values are separate. All right. I've talked to you about a little bit about the process. Another thing I want to note and just highlight is, well, what tool do we do this through? And a tool here that we use at Halter Ferguson is called eMoney. A lot of you may be familiar with it, using it, know it as your personal financial website. But this is an important piece of tonight's discussion because using this software, it's really accelerated financial planning capabilities over the years, which enhances the conversations that we're able to have. You know, we have the ability to model gifting throughout life and allowing clients to see, well, what does a hypothetical result look like? And ultimately what that does is it helps them make decisions. The other piece too is just being able to bring everything in. And that's why there's such a push on comprehensive financial planning. You know, it's easy to look at, hey, I want to make a gift, and how does this impact my scenario? Or, hey, I want to look at a retirement projection. What does that look like? But bringing all pieces together and also being able to model different scenarios, I think that really gives people confidence to be able to look out into the future and bring it back in the present day and say, hey, I've got all these contingencies in place. And even if I do this, my plan either works or it doesn't. And that really gives people that confidence, allowing to know if they can do things earlier than what they intended to do. Okay. The other piece that's awesome about eMoney is there's a vault portal. So if you go through an estate plan and make one, but no one can find it, it's not really that great, right? So the vault has a place where you can store digital files and all of those things related to your financial affairs. So that way, when things do happen, people know where to look and they can find it. It also tracks your net worth, which is important when you're evaluating your estate planning picture. And they're always making updates, so that helps. All right, enough about the tools in the process. We'll get into the actual content of estate planning and go from here. So I wanted to start you off with the most fun word that everyone hears, probate. Literally what this is it's a term for a legal process in which your will is reviewed and it's determined whether it's valid and authentic, right? It goes to court. Now, there are people that pass away that don't have a will. And that is what you may have heard the term called intestate before. Okay, so basically there's no documentation. It's left up to the judge. They're deciding, all right, well, trying to figure out who are the beneficiaries and the heirs and what assets does this person have. And then they're left to default by state law of how things are distributed. So it's not the most quick process because organization isn't there. And you also don't have control usually over how things go. It's not as streamlined. Both processes, whether you have a will or whether you don't have one, they both go through probate, but probate's just so much, unless it gets challenged for some reason, which it has to be usually a complex situation, probate with a will is far faster and it's easier on your family, much easier on your family. It's also, you know that it's getting, your wishes are getting taken care of. You'll hear a lot of people that they plan to avoid probate. The three main reasons that people want to avoid probate is because one, it's public record. So privacy wise, it's kind of out the window. Once things are in probate, anyone can look it up and kind of be nosy. Oftentimes it can be costly, whether it's executor fees, attorney cost, or things like appraisal fees. And then time's the biggest one. I mean, it can take sometimes months up to years, depending on how things shake out, to finalize the estate. And, depending on the situation, that some people don't have all that time. They need the assets to continue living. So that's why people set this up in the probate side. Let's talk about estate plan overall, right? So will is like one particular piece, but the estate plan is overarching. It's much more than that, right? So it's that process of everyone works hard to accumulate the assets that they have. They want to manage them throughout life, conserve them, and then transfer the wealth. But not only do that transferring, but do it in a legal way that's tax conscientious and also meeting your goals. So that's what a whole estate planning picture looks like. It's very important to the financial planning process overall. You can have a really good investment strategy. You can have great in protection as far as insurance, but if you don't have a good estate plan, that can be a downfall. And that's why we encourage it and having those conversations. An estate plan done right, really what it does is it reduces confusion. It ensures that the loved ones you intended to get the assets get them. Hopefully, it lessens conflict. And then the other piece is minimizing taxes and legal expenses. Now, just keep in mind that estate planning overall does include real property. So things that are immovable, like land, and then personal property. So like tangible and intangible things, contents in your house, your financial accounts, etc. And then one that is important and definitely up and coming is the digital space as well that encompasses that. I want to look here at the second part. So the essential estate documents and what they include. This is just kind of a high level. It's not all encompassing, depending on your financial scenario, whether the complexity, it may differ than these, but these are usually the staples. A last will and testament, power of attorney for your financials, a healthcare power of attorney, living will and advanced medical directives, and then trust. Just keep in mind that trusts aren't applicable to every scenario, but we will hit on them because they're important. All right. A will, also known as a last will and testament. Legal document, it's communicating a person's final wishes pertaining to assets and dependents. So what the will does is it'll outline what to do with your possessions, who to leave them to, whether it's to a specific person, a group, or a charity, and then other things that you're responsible for, like custody for your dependents if you have children, and management of accounts or other financial interests. So that's where the will, that's the role that it plays in the estate plan overall. Just keep in mind that your will must be filed with probate to begin that process, which a will takes effect at death. Okay. Wills can also have trust within them, which are called testamentary trust, and those take effect at passing. So will, some of the things that we encourage people to do is have conversations internally before you go see an estate attorney to figure out who might be a good person to name. For my guardian, who do I want taking care of my children? What skill sets would qualify them for this particular role? Do they live near me? Or, what am I looking for in that realm of a guardian? The other one is executors. So who's going to take care of your estate once you're gone? And an executor is appointed through a will. If you don't appoint one through a will or have a will, the state will appoint one for you. Another piece here is who are the recipient of assets. If you're specifying that in the will, you'll want to be thinking of that. Who do we want things to go to? If you don't have a specific trust, or are there specific line items that you want in the will to make sure that those instructions are adhered to? A lot of times you'll have what's called a letter of instruction or personal memorandum that will accompany a will. So not to get too complex, but with those, let's say I have a grandfather clock at home and I want to make sure that Tiffany gets it. I can specify by a letter of instruction or personal memorandum that I want to make sure that that goes to her. And also I would give this to the executor just to be sure that they had a copy of it too, and maybe talk with my family. So those are the pieces with the will. Wills are done individually, and most states won't even accept joint wills, which I know that sounds crazy, but there are some people that want to do a makeshift way around this and just do one will, and it's definitely not advisable. All right, financial power of attorneys. The most common one you'll hear is a durable power of attorney. They are in control, so they have a lot of control over everything pretty well. And not only are they able to act when you're cognizant, but they can also act in times of incapacity. Sometimes you'll hear a springing power of attorney, and you're able to put parameters more around, all right, what conditions must be met in order for this person to make decisions on my behalf. And then the last one here I want to mention is a non-durable power of attorney. Basically, that person is authorized to act on your behalf until you become incapacitated. And oftentimes incapacity requires a doctor examination or such to deem that you are technically incapacitated. You will hear a limited power of attorney sometimes, and that is just what it sounds like. I want to limit just this specific affair to this individual that they can make decisions for my behalf on and nothing else. For a visual, I thought this might help as an aid, just giving you an understanding of where each of them lie. And you can see here, springing occurs when someone's incapacitated. Durable gets to take effect in all scenarios, and the non-durable is just immediate once it's signed, but stops at incapacity. Healthcare power of attorneys. These have become increasingly more popular throughout the years, and basically what this is it gives a person the right to make healthcare decisions when you don't have the capacity to do so. You'll also hear this called a healthcare proxy, but basically when I'm thinking of a healthcare power of attorney, and we're having that discussion of, all right, who would be a good one? You know, whether you have a nurse in your family or a doctor or someone that shares similar values and you know that they would respect your wishes, they would be a good person to name as a power of attorney. One piece that I would mention with this is you'll want to make sure that you name successors too. You know, if your spouse is your power of attorney, your healthcare power of attorney, and you each get into the same car accident together, it's a good idea to have a successor that is there as a backstop as well. The other piece too is a living will and advanced medical directives. So the living will, it's a specific document that talks about, you know, what you would want and would not want to keep you alive. You'll often hear this, such as like pain management or organ donation. So some people have a DNR, so do not resuscitate, right? How do I feel about CPR? How do I feel about a ventilator? What about a feeding tube? Organ donation. Do I want to donate my body to science? What I would say about this piece is it really helps your family in that time of distress. And also that, some people don't want a feeding tube, and just making sure that those wishes are being adhered. Not always the most comfortable conversation, but probably important to have this conversation across your family and those important players, just letting them know of, hey, these are my desires and I'd like for you to respect them. If you do have a living will and advanced medical directive, the first person that I can think of that might want a copy of it would be your healthcare power of attorney, just so they know as they're making decisions what you want. Trust. Get into trust here a little bit. Again, every scenario is different. So what trust would be applicable to your situation is subjective depending on what your goals are and what your current financial status is. But there are many reasons that people use trust. Like some people use them to transfer property. Other people want to minimize estate taxes. There are spendthrift clauses in those, so preserving assets for minors are also making sure family members can't, just totally zero out the trust right away. There are also ways for people that are charitably inclined, if that's a goal of theirs, to use the trust to do so. Really, they can just, again, safeguard your assets for you if you can no longer handle them. One thing that I kind of found out, which I thought was interesting, is Social Security payments can't be made to a trust. So you always want to have an outside bank account too. Some people fund the trust during life. Other people wait for death for it to be funded or incapacity. Just remember that wills are at passing, and that trust, they can take place throughout life depending on how you name them. Sticking with this role real fast of, hey, important players. If you establish a trust, you'll want to make sure that you have people in mind for trustee. Who do you want to name? Do you have a successor? And then there's also components of a corporate trustee, if you would like that, in case you don't have like a third backup for that. One reason that people really go to trust is they like them because they're private, and there are upfront costs, but a lot of times people like the fact that they know they're going to avoid probate with it generally. So that upfront cost may be worth it to them, having that peace of mind that they were able to streamline it. Two terms of trust, you'll hear revocable versus irrevocable. So a revocable living trust is one you'll often hear. And that one's nice because it flows through your individual tax return. It doesn't create a whole lot of complexity. You have the cost to establish it, but unlike an irrevocable trust, that's usually a little bit more costly to manage. Revocable can be more cost effective. It can be changed at any time during the lifetime of the owner or the grantor, which is the person who establishes that trust. And it can be totally destroyed too, if they want it to be. An irrevocable trust, that's one that generally, because there are specific clauses that allow you to adjust it, but it's a lot tighter. So they cannot be changed, revoked after the agreement's been signed. And one thing to keep in mind is that a revocable trust at someone's passing will become irrevocable. So it makes that transition. Okay. One thing that people like about irrevocable trusts is that when certain conditions are met, the assets can be removed from the trustee's estate and thereby potentially reducing the value of it and its associated tax liability. Again, you just have to remember too, depending on where the estate laws are at that time and how that shakes out in your picture. Other types of trust, don't want to go into trust too much, but I do want to hit on these. Charitable trust, as I said, usually someone would use those to lower or avoid estate and gift taxes if needed. Special needs trust, set up for someone who receives government benefits, and this is set up so they don't get disqualified from those government benefits that they're receiving. Testamentary trust, we talked about it a moment ago slightly, but again, that's one that's created by the will, and it provides for the distribution of those assets that don't pass by contract. And I'll talk to that in a moment. You can have multiple testamentary trusts established in a will. So keep that in mind. Other ones that you'll hear, it's called a Q-tip, basically just helping. Again, some of these scenarios, talking to an attorney was going to be the right thing, but a Q-tip, it's making sure your spouse is taken care of and that assets flow appropriately upon the surviving spouse's passing to the children. Credit shelter trust, just making sure that you minimize or avoid estate tax liability. Spousal lifetime access trust, those right now are becoming popular because of the Tax Cut Jobs Act sunset. A lot of attorneys are turning to these. And again, it's making sure that one spouse makes a gift into a trust to benefit the other and removing assets from their combined estates. And then a QPERT, I hit on this, it's a qualified personal residence trust. Sometimes people put a home into a trust if they want to give it and transfer those assets. More comes back to the goal of just like the dream home component. And again, talking to a state attorney if that's applicable for your guys' situation. All right, enough about trust. We'll talk about beneficiaries or accounts that pass by contract if you want to hear the actual legal term. But IRAs, they're so important that we're continuing to review beneficiaries on your IRAs, qualified retirement plans, your 401ks, 403bs, pensions, 457s, etc. Life insurance policies, annuities. And then you may have heard of transfer on death accounts or payable on death accounts. Both act in a very similar fashion. TODs, transfer on deaths, are at brokerage firms, and payable on deaths are usually at banks and credit unions. One piece to note about your beneficiaries. An IRA, you can name any beneficiary that you want, but just keep in mind with workplace plans, oftentimes if your spouse is not named the primary beneficiary, you'll have to get written consent by your spouse acknowledging that they understand they're not the primary beneficiary. Okay. Some legislation things that I want you to be aware of. So the Secure Act, you may have heard of that. That came through at the end of 2019. But what that did is it got rid of stretch IRAs for almost everyone. There are some specific clauses within inherited IRAs. So basically what they did is you have to get rid of the IRA that you inherit within 10 years. There's not a required minimum distribution for it, but the account just has to be depleted within 10 years. So that has changed the landscape of how we are conducting Roth conversions and such, and I'll hit on that more for non-spouse beneficiaries. Charitable goals. Gifting during your lifetime and or at passing. This is a conversation we're increasingly hearing as people plan and continue to move throughout their plan. Hopefully, by the work that we've done, their picture gets better and they're able to have these conversations and accelerate giving. And some people don't wait until passing anymore. They do it throughout their lives so that they can see those recipients use the dollars. And family members, maybe they needed it now more than at your passing. There are limitations to these gifts. So cash contributions, usually 60% of adjusted gross income can be taken as an itemized deduction, except for the fact that in 2021, the CARES Act allowed it to be 100. Appreciated securities, those are 30% of AGI. And when I'm thinking of appreciated securities, you probably have heard of donor advised funds, which have become increasingly more popular because of the Tax Cut Jobs Act. And the reason that these have become more of a usable tool is with the raised standard deduction, a lot of people stopped itemizing. So a way to take advantage of that was to bunch, what we call bunching, charitable gifts into 1 year and then give it out over subsequent years. Maybe you do 5 years of gifting in one. And so that's become a popular strategy for clients as well. The other thing that it did was it capped state and local taxes at 10,000, which made it harder for people to itemize too. Keep in mind as well, there's another way that people can do charitable intentions through an IRA. As long as you're over 70 and a half, you can give up to 100,000 a year by way of qualified charitable distribution. And when you're doing these gifts, you just want to make sure that in order to get the tax deduction, that it's a 501c3 qualified organization. If you're not itemizing and you're taking the standard deduction right now, one thing that you can do if charity is something that you enjoy is you can give $300 or $600 if you're joint for an above the line deduction if you don't itemize. Continue with the giving theme. As far as lifetime giving, so two terms you may hear are the annual gift exclusion and then a lifetime estate exemption. So for 2022, a person can give $16,000 a year to any individual without having to file a gift tax return. If you're married, you could do $32,000 a year to any person. Just be cognizant that a gift tax return may be required because they call something that's called gift splitting. And just depending on how you do that gift, you may be required to do a form. And 2022, I just want to reiterate this. It may seem like I'm repeating here, but keep in mind, it doesn't only apply to a cash gift. So someone could give some type of property, they could give a stock, etc. As long as it's under that $16,000 value, they're fine. There won't be any estate or gift tax consequences. The gift tax form is a Form 709, in case anyone's curious. Now, the estate exemption. So this is the piece that's, a lot of people are hearing about. An individual can leave in 2022, 12.06 million to heirs and pay no federal or gift tax. Married couple, double. And December 31 of 2025, if Congress does nothing, that's going to be cut in half. Okay, so just because you gave, let's say you gave 50,000 to one individual person, you will have to file a gift tax return for that, but you won't have to pay any tax on it because it's just going to draw down your lifetime estate exemption at that time. So that'll be removed to To continue talking about this piece, there have been talks that, it may be less than that, but as it stands, when it comes to 2025, that estate exemption's going to be just over 6 million as it is right now, unless new legislation gets passed between now and then. And one thing that they have clarified is if someone does gift over that amount, they can't claw back and make the giver punished for over giving during this period. I know that that's been something that a lot of people have been writing on forums and such online about. So the other piece here, other notable legislation pieces, the Secure Act again, RMDs, required minimum distributions, have been adjusted to 72, but again, you can still do QCDs, qualified charitable distributions, at 70.5. The Secure Act also is the one that affected the inherited IRAs that I just spoke about earlier. Medical and educational expenses. There's no limit on the amount of tax-free gifts that can be made for a qualified education or a medical purpose. As far as the educational piece, it has to be for tuition. So room and board and books and such, you can't pay directly to the institution for that, but tuition you can. That does not use any of your gift exclusion, nor does it use any of your lifetime estate exemption, that 12.06 million number that I just spoke about. So that's another strategy people can use. Medical gifts must be made directly to the medical care provider to qualify for the unlimited gift tax exclusion. So I can't give 30,000 to Tiffany and have her pay off the medical. I have to go straight to the medical provider and pay it. That's pretty broad. The medical gifts one is very broad. But one area of scrutiny is cosmetics. They don't really accept that. So yeah, just be aware of that if that ever comes to fruition. And political organizations also have some exempt qualifiers to them too. 529 plans. These are fun ones. 529 plan is basically an investment account. Again, they come in a wide range of options. All states kind of have their own plan provider, and you can establish one at many places. But it's basically for the designated beneficiary, whomever you want to help out with that educational goal. In recent years, something new has come about to where you can use 10,000 a year to help pay tuition expenses annually for K through 12. So that happened in 2017 as well with the Tax Cut and Jobs Act. That's something new that hasn't always been an option, and that it brings about some possibilities for people to help as well with private school costs, etc. And then you could pay up to 10,000 of lifetime qualified student debt now. That wasn't an option before the Secure Act in late 2019. So there's definitely been some involvement that's taken place on these fronts. For Indiana residents, just want to remind you, if you fund $5,000, or let me explain it this way, any amount up to $5,000 that you fund to an Indiana 529, you get a 20% in-state tax credit. So that will flow through on your Indiana tax return, not your federal. But that's a really good, Indiana has one of the best 529 plans as far as that tax benefit in the country. All right, so I know that was a lot, but let's take it all back of how does this matter to you? And maybe what can you do based on this conversation of everything we just went through? First piece is, if you have an old document in there that maybe is dusty or been filed away in a filing cabinet for a while, get it out. Look and see who's named as my important players. Do they still apply? Do I want that person to still be my power of attorney? Or how is their mental capacity? And, are my kids of age now to where maybe I could name them? Review those pieces. Review those who maybe you've named in your will to receive assets to make sure they're still applicable. Utilize the gift exemption each year. If you have a desire to give, you can give up to $16,000 per person per year. Roth conversions. Look and analyze whether Roth conversions are fitting for your scenario. With that stretch IRA provision that is now gone for inherited IRAs, if you want to help the heirs out that you named for beneficiaries, maybe Roth conversions make a lot of sense to help streamline and simplify that process for them. Utilize paying medical or educational expenses directly to the institution. That's one of the best ways that you can, make a legacy difference and also not have any impact to your overall estate picture. And then last but not least is maybe it's time to have an estate plan review with a qualified attorney, just ensuring that you've planned for proper planning opportunities, not only that you're capitalizing on the scenario if something were to happen to you today, but also potentially what that environment may look like for you as things sunset beginning in 2026. And then at this time, I'm going to open it up for the Q&A questions. And then also just to let you know, our next financial planning webinar, really looking forward to it, is going to be about educational. So expanding off of those 529s and how can we do planning for the goals of education.
Wonderful. Thank you so much, Ben. I think that was really great content. Hopefully a lot of you feel brushed up on some of the estate planning basics and maybe got some tidbits out of there too. And certainly it's always an open invitation for you to sit down with us and see how we can look at that big picture and how things have changed and how we can implement some of these strategies. We do have a couple questions, and I encourage all of you to submit any questions you might have to either the Q&A or the chat field, and we'll take a look at those. But we do have a couple questions here to go through, Ben. One was when we were on the topic of wills. So I think what you had said at the time was wills must be filed with probate to take effect. Can you expand on that a little bit?
Yeah, so a will, there's a specific time frame, and I don't have that off the top of my head, but you have to file the will with the probate courts in order for that process to kick off and begin it. And then there is a certain time frame, so like you have to make sure you meet that time parameter in order to initiate the process, and that the will is upheld accordingly as planned.
Perfect. Yeah, and this is just to verify that it's a valid will and handle any disputes if anyone were to contest the will, but it may not have to go through that formal probate process after, but it does need to be filed with the court ultimately. Thank you. Another question here, and this is about the CARES Act. So the question is, does it only pertain to 2021 or going forward? And it is, in fact, just for 2020 was the CARES Act extended into 2021. So that is now behind us at this point. Okay.
Yeah, one fun fact with the CARES Act, not to regress and look in the rearview mirror, but that was one of the only few times that they had suspended required minimum distributions. It had been done before, but it's not very regular. So that was an interesting piece of an outcoming of the CARES Act.
Excellent. Those are all the questions that we have at this time. We do have a few more minutes before 7 o'clock comes up here, so please don't hesitate to enter any questions before then. And of course, you all know you can reach Ben and I directly, and Lisa, of course, at any time for guidance and support. And we look forward to those chats. So we can give it another minute here, see if we have any other questions, but otherwise, Thank you so much for joining us. It means so much to have you all as a part of our family here at Halter Ferguson, and to be able to share our team with you and Ben and some information. We always enjoy doing that. So thank you.
Yeah, thanks for staying on and listening, guys. And I hope that you found something of value. I know it's not the most glamorous topic all the time to listen to, and that was a lot of information thrown at you. So thank you, guys, and I hope that helped.
We do have another question here, Ben. So can you think of a scenario where a trust would not be applicable for a client situation? And that's a great question, because we do often say, trusts aren't for everyone. Not everybody needs a trust.
Yeah. So when I think about this, I mean, if you have a lot of assets that just pass by beneficiary, and besides, I mean, how you titled different things. So like if the home is jointly titled, and bank accounts jointly titled, etc. Like a trust may not be warranted for your scenario. And I think a lot of times, I mean, there are a lot of people that don't necessarily need it, or maybe a trust needs to be a testamentary trust established at passing, but you may not need it throughout your lifetime. And again, that's just kind of depending on, like, further analysis is needed to, say that for that specific picture of individual of whether you would need one or not, and maybe a conversation with the state attorney. But the reason these things are important too, and Tiffany and I were talking about it before, is just, staying on top, like the state laws change, and making sure that those important players are still applicable.
Yeah, that's a great point. I think the only other thing I might add is, now this is more specific to Indiana probate. So if your probatable estate is less than 50,000, there is no probate required. So if you have all the named contracts, the beneficiary, there's a designated person all your assets will go to, you avoid probate in that case. So if a probate avoidance is your goal, you don't need a trust in that scenario. Okay, another question here. Let's see, where did it go? Okay, so if the spouse, this is a good one. If the spouses live in 2 different states, how do you, or where do you file the wills?
I would say, and this is just kind of off the cuff, so I need to fact check this, but I would say it's your primary state of residence, the one that you kind of like, in order to become a resident of the state, you have to live there a certain amount of times per year, as far as like time over that elapsed period. So that would be my go-to. But again, in the beginning, as I stated as well, the state laws are different for every state. So that would need some further looking. But I do like the question.
Yeah, that's a great question, and one that I hadn't thought about before. And I can tell after a little bit of digging here that it's going to be dependent upon the state where the individual died, as well as to where that will be filed, what state and what county. But we can certainly follow up in more detail on that. That's an excellent question. Okay, here's another one. What is a negative to have children jointly named on your home, for example?
As far as the home, I think it depends on what are your intentions of who do you want to have the home at the end. How many children are we talking about, and will it create some jealousy or animosity in the family? That's that piece. Where I see this same issue but different is, let's say that you have a child named on a bank account and they're helping you with getting out payments and such for you. They're acting as POA. When you name them jointly, upon your passing, it's going to go directly to them. Whereas, other ways, if you want to split it amongst family, I wouldn't have them named on it. So that's the one area where it kind of, where that issue comes into play, that instead of just adding someone as like a trusted person on the account, they give them actual registration on the account, and that makes it pass to that person particularly.
Another caveat I might add in that scenario is when you are naming an individual jointly on something, you are giving them partial ownership, and that can result in a gift as well. So you need to keep the tax consequences in mind as far as recording that. Okay, I think we have, I think I saw another question, or maybe just some cheerleading here. Doug is emphasizing that if you're one of our clients who doesn't use e-money, and Doug is one of the best at using e-money regularly to track spending. I love how much he gets in there, and he's encouraging all of you to do the same if that's something that you haven't dabbled in, just taking advantage of the client portal side of the software and all its capabilities. So thank you for that, Doug. We appreciate that. Okay, I don't think I see any further questions here at this time, Ben. Okay. All right, I think that is it for now, gang. And man, we just saved you one more minute of your evening. It's 6:59. You are welcome. Any last words, Ben?
Yeah, thanks for your guys' time, and I look forward to talking to you guys in the future. See you for the educational webinar. Take care, guys.